morning, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the film.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for our online talk today entitled An Overview of Immigration Law in Malaysia. My name is Vivien, and I'm an associate with Wong and Associate. I'll be your moderator for today's session. Before we start, allow me to introduce the firm and what we do. Wong and Associates is a mid-sized law firm that was founded in 1985 by Datuk Wong. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, an employment, industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But since the implementation of the COVID-19 Movement Control Order, or MCO and now RMCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel, and we have continued this practice until now. This is the 26th talk in our MWK online talk series, and today we're expecting about 77 people who have registered online. Please feel free to visit our website at mawengkwai.com for more information on what each of our team does, our online products, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please feel free to contact us for a complimentary legal consultation. Details will be given at the end of this talk. Allow me to introduce our first speaker for today. Our first speaker is Ms. Sohaimi. She's an associate in our dispute resolution, individuals and families, and Sharia departments. She holds a Bachelor of Laws from International Islamic University Malaysia, and she was admitted to the High Court of Malaya in 2018. Anis's practice areas include general litigation, debt recovery, contractual disputes, joint management body disputes, Sharia estate planning, professional malpractice, and criminal defense. Following Anis is our next speaker, Mr. Wong Chee. Chee is our associate in our dispute resolution and individuals and families departments. He graduated with a Bachelor of Laws from the University of Leeds in UK and was called to the Bar of England and Wales in 2018. He was then admitted to the High Court of Malaya in June 2020. Our speakers hope to complete today's talk by 3:45 and thereafter proceed with a Q&A session. So if you have any questions, please don't forget to post them up on Slido and we will address them later. You should have received a link to Slido during your registration for this talk, but I will leave this slide up for a while so that you can scan the QR code before we move. Alternatively, you can go to Slido's webpage, the left-hand corner of my slide, and key in the code 18668. I repeat, 18668. Since our talk today is to provide an overview of the immigration law in Malaysia in general, including common immigration-related offences and employers' obligations when employing foreign employees, we will give priority to those questions. If we have extra time, we will endeavour to answer your questions relating to other or more extensive part of this talk as best as we can. If we do not have enough time, please fill in our feedback form and we will get back to you as soon as we can. Our talk today will cover the following points: control of entry and entry permits under the Immigration Act and Immigration Regulations 1963, immigration-related offences such as illegal entry, overstaying, and falsifying documents, employers' obligations when employing foreign employees, powers of immigration officers to conduct inquiries, interrogations, and to search and arrest. For today's session, our first speaker, Anis, will enlighten you on the control of entry and entry permits under the Immigration Act and immigration regulations, followed by immigration-related offences such as illegal entry, overstaying, and falsifying documents. Chee will then take over to briefly explain to you the employer's obligations when employing foreign employees, the powers of immigration officers to conduct inquiries, and so on. With that said, I will pass the floor to Anis. Over to you, Anis.
Thank you, Vivien, for the introduction. Just let me share my slides before I begin. All right. Thank you again, Vivien. Before I begin, allow me to thank everyone. Thank you for choosing to spend your Friday to listen to our talk today. And I hope that you are joining us in a place where everyone, you and your loved ones, are safe and healthy in this time of COVID. So today's topic, so I will be covering two topics as informed by Vivien. My first topic will be the control of entry and entry permits under the Immigration Act. So this part of the talk is a bit technical. Please bear with me before we go into the more interesting discussions involving offences, and before I pass the floor on to Chee, who will go into the duties of employers and so on. Before we go into the entry and control of entry, it is worth noting the applicable laws in relation to this topic. So the primary legislation include the Immigration Act and the Passport Act. So the Immigration Act provides for the admission and departure and removal from Malaysia, immigration offences, functions and powers of the Immigration Department, and special provisions for East Malaysia. As you can imagine, it encompasses a wide immigration law, encompasses so much. So today our focus will be on the entry and the offences and function and powers of the immigration officers. The other primary legislation is the Passport Act, which, as the name suggests, governs the possession and production of travel documents by persons entering or leaving or travelling within Malaysia, and to provide for matters connected therewith. So these two acts are not exhaustive. So supporting these acts are the subsidiary legislation, including immigration regulations, which will be the focus of our talk, the first part of our talk, which governs the entry permits and passes. And other subsidiary legislation include immigration regulations relating to the administration of depots and also compounding offences. We will go into that later. So when we talk about entry into Malaysia, a layman, the first thing we think about is, passport, airports, whether we need a visa to enter that country, but there's more that goes into it. So apart from considerations, whether you are a prohibited person, whether you can enter that country, and stuff like return tickets, having enough money, and filling in the relevant forms in the airport. When we talk about entry under immigration law, it is already specifically defined. So entry under the Immigration Act defines entry in the following manners. Entry can either be by, in a case for the person arriving by sea, is when he disembarks in Malaysia from the vessel arriving at sea. For the person who arrives by air, it is at an authorized airport, and when he leaves that airport, he's considered to have entered Malaysia. and entering by land and proceeding to immigration post, and when they leave that post, that is considered an entry into Malaysia. And in any other case, an entry into Malaysia is by land, sea, or air. So from this definition, we can get a general idea that entry, basically how it's controlled, is by having designated areas, and these designated areas can either be by land, sea, or air, so either the control posts, landing places, or airports. And these points of entries are specifically prescribed by the minister, and if you enter Malaysia at any point which is not an authorized entry point, then you will be considered as having unlawfully entered Malaysia. That's one aspect of controlling entry into Malaysia. Another part of controlling entry is by the documents required. So although you may have arrived at the point of entry, you cannot proceed to leave that entry point without a valid entry permit or pass. And this is applicable to non-citizens. So citizens don't require this added requirement of entry or pass, but you can see here that the relevant documents are then divided at the permit or pass. Now, permit and pass, these are in addition to passport and visas, which are different terms. So let's go into what entry permit is. So entry permit, under the law, it's called entry permit, but what we recognize it as permanent residence. So to get a permanent residence, you have to prove that you fall under any of these categories, whether you are an investor, an expert, or whether you're a professional, or if you're a spouse of a Malaysian citizen or a child of a Malaysian citizen. And if you don't fall within these three categories, you can also get permanent residency using the point system in place in Malaysia. There are also programs and initiatives by the government which allows for permanent residency, such as the MM2H, which is the Malaysia My Home for You initiative, which is to encourage permanent residents, non-citizens from other countries to stay in Malaysia if they fulfill certain requirements. But today we will only go into these four main entry permits. So the first is investor and expert. So it is issued, an investor and expert permit is issued to any individual with a minimum of $2 million in fixed deposit, which is deposited in a bank in Malaysia. And this deposit can only be withdrawn after 5 years. And for you to be issued with this permit, you must have a Malaysian sponsor. So in all of these permits, you will see there's a requirement of a sponsor. So a sponsor generally just means someone who is a citizen of Malaysia and who's 20 years older. So that's the requirement for investor. For an expert, it's similar to the next permit, which is for professionals. They're similar in that they are issued to professionals who are recognized and who have outstanding skills in certain fields, and they require the recommendation from a relevant government agency or any agency in Malaysia that recognizes that field, and they must obtain a certificate of good conduct from their original country, the country of which they came from. And you also need a Malaysian sponsor, and for the added requirement for professional permit is that you must have worked in a government agency or private company in Malaysia for a minimum number of years, 3 years, as certified by the relevant agency. So this is what distinguishes between the expert and professional. They have this added requirement that you must have some work experience. So the next permit you can get to obtain a permanent residence is if you are a spouse of a Malaysian citizen or a child of a Malaysian citizen. So this is what we normally come across. And it has similar requirements like the previous entry permits, except that the sponsors will be either the spouse or the parent. Basically the Malaysian citizen, if you recall, the sponsor must be someone who's a Malaysian citizen. In this case, it would be the spouse or the parent who is a Malaysian citizen, which entitles them to have this permit. And you must also have your wedding certificate or anything which evinces your legal marriage to have before your entry permit can be issued. So if you don't fulfill the requirements under these first three categories, Malaysia does allow a foreign national to obtain permanent residence if you can get 65 marks based on these following categories. So it's age, qualification, duration of stay, family ties, value of investments, working experiences, and proficiency in Bahasa Malaysia. So how the score will work is, for example, if you're between the ages, I think, of 18 to 35, you will get less marks than you would if you were someone above the age of 35. Qualifications means based on your academic qualifications, from starting from diploma, degree, PhD, and master, you will select the highest qualification, and the higher the qualification, the more marks you get. So PhD, I believe you get 10 or 15 points. And you will also get points if you've stayed in Malaysia more than 5 years. If you haven't stayed in Malaysia more than 5 years, then you don't get the points under this category. For family ties, you will get points based on the connection that you have to a Malaysian citizen or the permanent resident. So for example, and it also varies, the points varies depending on who that relative is. So for example, if you have a spouse who's a Malaysian citizen, you would have a stronger tie to that person, rather than if you would have a stronger claim to you would have a higher point as opposed to someone who only is married to a permanent resident, for example. Or if your mother is a Malaysian citizen, you get more points for having a mother as a Malaysian citizen than you would if a mother was a permanent resident. And the values of investments is broken down further. It depends on how much money you deposit and how much you've invested into a Malaysian, you've deposited into a Malaysian bank. And it also considers if, for example, under a business, you have how many job opportunities you've created. So if you've created, if you started your own company and you have employees ranging from a number of 15 to 10 employees, and you've created 10 job opportunities, you would have less points compared to someone who's provided 500 employees with job opportunities. So these all count to add up points, and there's for those that can go above the number of points, there's a maximum. So for example, the working experience in Malaysia, you will have a point for every 5 years, if I'm not mistaken, and you can only have a maximum of 5 years. So if you have working experience in Malaysia for 5 years, then you already get the full marks for getting the points under the system. And the proficient in Bahasa Malaysia is that if you're proficient in Bahasa Malaysia, you will get 5 points. If you're not, then you don't get any points. So depending on the category, the points vary, whether you get a lot, a little, or you get none at all. So having covered the different type of permits, we now move on to passes. This is generally what is most people look into, and you can see there's different type of passes, and there's so many. So we will go into the common ones and we'll just touch on the main points of each pass, which will help you distinguish under which pass is relevant to you and which you should apply for before you consider traveling to Malaysia. So first, which Chee will be touching further on, it will be in relation to employment pass. So these are the passes which allow you to work. Not to say that the other passes don't allow you to work, but the other, if you are applying under different type of pass, you would require written consent by different people. So for the employment pass, obviously you intend to stay in Malaysia to work. And what is to be noted here is that the employment pass is called it by a different name for people who intend to work for Sabah. So if you want to come to work in Malaysia, make sure you apply for the right pass, whether it's an employment pass or a work pass, which by normal English seems like the same thing, but it's different. So an employment pass is for West Malaysia and for Sarawak, whereas a work pass is for Sabah. So in both cases, you are not allowed to work. You have to work at the place stated in your employment pass unless you get written consent in writing by the controller. So controller here just refers to any immigration officer who's been charged with that duty. Next, we move on to the dependence pass. The dependence pass is basically anyone who is dependent, is relying on someone who holds a valid employment pass. It also covers, for example, if you have a student pass and where you're studying as a master or PhD, and you're bringing your family along with you. So you would also be covered under the dependence pass. But you have to note that if you are working in Sabah, you don't apply for a dependent pass, but you have to apply for a visit pass under paragraph 4. So if you look at the first bullet point under the visit pass, this is the most commonly applied for, because you can see there's many circumstances. It's either you apply for a social business or professional visit, for temporary employment as a tourist, or as mentioned earlier in paragraph 4, which is as the dependent child accompanying or joining the holder of a work pass in Sabah. So you have to make sure that you apply for the correct pass. And because of these different paragraphs, that's why if you log into the the Immigration Department's website, you will see they have visit pass, and in brackets they have social, business, tourist, temporary employment. So this is how you get the breakdown of the different type of passes, and from there you can decide, you can choose the most relevant to you to apply. Under a visit pass, it should also be noted that there are further conditions that the holder of visit pass shall not engage in any form of paid employment or business, or give political lectures, speeches, or engage in any political activity during the validity of the pass without the consent in writing of the minister. What's noted here is the difference in who you get the consent from. So for the dependence pass, you have to get the consent from the controller, which is any immigration officer, which is considered easier to apply. But nonetheless, it's still hard to apply under a visit pass to get consent in writing of the minister. And the difference between why one is applied under the controller and one is applied under the minister is that it's taken to suggest that the minister, wherever it appears, any decision by the minister, wherever it appears in the regulation or the Immigration Act, his decision is final. So there's no appeal against his minister except by way of judicial review, which then is also restricted and only applicable in certain circumstances. So that's why you should, that's the importance of distinguishing which pass and who to apply for certain to vary conditions under the pass. Next, we move on to the residence pass. This would be accompanying those who have a permanent entry permit under the permanent residency, and their spouses and children would be applying for the residence pass to stay in Malaysia. And again, there's a condition to say that you cannot give any form of political lectures and speeches, or be a member or associate with any organization, unity, union, or association affiliated to any religious or social body which is not officially recognized under any other written law. So it's to be noted here that the visit pass and the resident pass has these additional conditions which don't seem to appear under the regulation itself, but there are certain restrictions that apply to those passes as well. We won't go into that much detail, but the other passes include transit pass and student pass, which is very self-explanatory. The transit pass is when you are not leaving that point of entry, you're just passing through onto your next destination. And the student pass is where you apply when you want to continue your studies. And the requirement for that is that you must be accepted first before you're allowed to travel into Malaysia, and you must make sure that you comply with the requirements. Otherwise, your pass will be revoked if you don't turn up classes or you're not retained as a student. Then the other passes include special pass and landing pass. Special pass, it will make sense later when we cover the offense of overstaying, because these are certain special circumstances which you can apply for a special pass. So this is to determine whether you are entitled to a permanent residence, or you have an inquiry, there's an inquiry against you to determine whether you're a prohibited immigrant. So these are certain circumstances where you can apply for a special pass. Mostly, it's usually widely applied for those who, say for example, they have a pass, the time limit, the period is almost expiring, but they cannot get the permissions within time, so they will apply for this before they can proceed. Otherwise, they will be considered unlawful entry. And the landing pass is relevant for those who are just traveling by sea, who are just visiting and don't intend to leave the aircraft that they arrived in Malaysia in. So we've covered the more technical parts. Now I move on to immigration-related offences such as illegal entry, overstaying, and falsifying documents. So basically, the immigration offences are quite straightforward in that when you enter illegally, then you are in breach of offence. So if you are found to have unlawfully entered Malaysia, the penalty is that you will be imposed with a fine not exceeding 10,000 ringgit or to an imprisonment for a term not exceeding 5 years or to both, and shall also be liable to whipping of not more than 6 strokes. For the offence of overstaying, the penalty that is carried is the fine of not less than 10,000 ringgit or imprisonment for a term not exceeding 5 years or to both. And for falsifying documents, is a fine of not less than 15,000, but not more than 10,000. And for a prison term, not less than 2 years, and not more than 10 years, and with a whipping not more than 6 months of general plan. What is to be noted for this is that there are many situations where you may question, does it fall under illegal entry or overstaying or falsifying documents? So a few examples I can give is, for example, if you are stopped by the immigration officer and you say that you do have a permit and pass, but it's expiring. So what do you do? Are you in breach of the offense under the Immigration Act? So if, for example, you enter into Malaysia just as a tourist pass, but then you take up employment. So that is a clear breach of the requirement to have a permit to enter Malaysia. So you're breaching that, and because of that, you can say to have had a lawful entry, and it is a breach under Section 6 of the Immigration Act. There's also situations where foreign employees will also say that, okay, I have a permit, I have my passport, but I don't keep it with me. It's with the employer, or it's kept with someone that they trust, citizens. Is that a breach of an immigration offense? In that case, the law provides that you are not allowed to be in possession of someone else's pass. So when you give it to someone else, that person is in breach as well as you for not having it on yourself, because it is a requirement that you travel and you keep your travel documents on you. And there's also the situation, for example, you have the relevant documents, you've applied for the relevant permits, you comply with everything, but due to circumstances that are out of your control, like for example, the MCO, you're not allowed to travel, you cannot leave Malaysia within the time that you're supposed to leave, whether it's considered overstaying. So like I said in the example earlier, that if you're faced with this, you can apply for a special pass, failing which you will be deemed to have overstayed, and the immigration officers can take action against you. So the law has already specifically outlined the penalties that will be imposed against you. So most people will question, because the law has a guideline, what is it that the courts usually mete out? So actually, for all of these offences, except for falsifying documents, which is under the Passport Act, for illegal entry and overstaying, there are actual there's the compounding offences regulations which state that these offences can be compoundable. So what that means is that there can be alternative penalties, which is a compound of RM 3,000 ringgit and cannot be more than 3,000 ringgit. So that's usually what is the penalty given to those who are found in breach of these provisions. During the MCO as well, we also saw not common offences, but we saw many foreign nationals who were detained at the immigration depot during the MCO for just being out, but they were allegedly being investigated for failure to produce travel documents. So for example, you can have all the necessary travel documents with you, but can the police officers still detain you? And the answer is yes, because they are allowed under the Act to investigate, to make sure that the document that you're holding is valid and it is not a forgery. So under the provision, so you may do everything right, but you may still find yourself in a situation where you're detained or questioned by the authorities, because they have this right to check your documents, and while they're checking, they can detain you as a measure of caution. So I've covered all of the offences for individuals who are in breach of immigration offences. Now there's the question of, for example, if you're not the person who's in breach of these regulations and laws, what if you're the employer who knows, or even if you're not the employer, what if you know of someone who's in breach of these laws? So what happens next? For that, Chee will take over. Chee, I pass the floor to you.
Hi, thanks Anis. Thanks for, so Anis just now has covered the different passes, travel permits, and also certificates. Let me just share my screen for now. Okay, so today I'll be talking about the employer's obligations when employing foreign employees, as well as the powers of immigration officers. So before I go on to talk about employers' obligations, I would just want to point out the differences in the interpretation of employees here. This is provided in the the Employment Act. So employer, as defined in the Employment Act, as employer is a person who has entered into a contract of service to employ another person as employee. So that is quite straightforward. But employees under the Employment Act, there are two different interpretations. So one is the domestic servant. Here, as you can see, under the Employment Act, it defines domestic servant as any person in connection with work of private dwelling house. So they are not related to trade or businesses or professions. So their examples are cook, house servant, drivers, or even gardeners or maids. Employee, on the other hand, is quite, it covers a wide range of people. So it's, as long as it is any person who has entered into a contract with services with an employer, you are considered an employee. So in terms of, so in relation to today's talk, we're talking about foreign employees. So under the Employment Act, it defines foreign domestic servant as a domestic servant who is not a citizen or permanent resident, while the foreign employee is defined as employee who is not a citizen. The reason why I want to talk about this difference is because when I talk about the employer's obligations later on, there is some slight differences in terms of their obligations. There are three main duties that the employers, the three main obligations that the employers should be aware of. The first is the employer's duty to inform or furnish information to the Director General of Labour. So when I say inform, when I say furnish information, what do I mean by here? So informing the Director General of Labour about the employment of the foreign employee, or furnishing information is also in regards to the employment of the foreign employee. So you have to furnish documents such as the particulars, or so basically all the information regarding the employee. Now, there is a timeline for you to do it. The employers should inform the Director General of Labour. As regards to foreign domestic servants, you should do it within 30 days of the employment. The foreign employees will be within 14 days from the employment. So this is the difference that I was talking about earlier. Now, what if you don't do it within that period of time? So employers, if found guilty of this offense, regardless of whether or not it's a foreign domestic servant or it's a foreign employee that they employ, the employer will be liable to a fine of not more than 10,000 ringgit. Now, the second duty is also to inform the Director General of Labour about the termination of service of the foreign employees. So there's no difference here in regards to either employee or domestic servant. Here, both applies equally. So regardless of whether the services is terminated by the employer or by the foreign employee or foreign domestic servant himself, and or upon expiry of the employment pass granted by the Immigration Department, or by repatriation or deportation. So as long as the services is terminated, the employer has a duty to inform the Director General of Labour about the termination. So you should do it within 30 days of the termination. And if you do not do it within that 30 days, and if you're found guilty of this offense, you are also liable to a fine of 10,000 ringgit. Now, I should point out here that termination of foreign employees or foreign domestic servants also includes situations where the domestic servant, usually in cases of domestic servants where the domestic servant has absconded or has flee from the place of employment. That will amount to a termination of service. Now, before I move on to the third duty, I would also want to point out another duty of another obligation of the employer, which is not stated in the Act, but I would just want to highlight to the audience here is that the employers have a duty to ensure that the foreign workers, upon the termination of service, you should ensure that the foreign workers are deported back to their origin countries. Now, moving on to the third one, duty to ensure that the foreign domestic servants or foreign employees have valid permits. So as Anis has mentioned just now, foreigners, you need to have the necessary valid permits and also visas to enter Malaysia. So as an employer, you also have an obligation to ensure that the workers, the employees, or the domestic servants that you employ, they have the necessary valid permits in their possession. Now, if you are found guilty of this offense, you will be liable to a fine of not less than 10,000 ringgit, but not more than 50,000 ringgit, or imprisonment of not exceeding 1 year, or both. This is applicable to each employee. So if you're talking about 2 employees, they will be 2 separate charges against you, and you'll be fined or imprisonment. You'll be liable to imprisonment for both charges separately. There's a case called the case of Wong Wei. Here, the case facts is that the immigration officers, they raided the employer's factory, and they found out that these 3 foreign workers did not have the valid permits. So in the magistrate's court, the magistrate acquitted and discharged the accused of all 3 charges, because as I said, there are 3 foreign workers, so he's charged with 3 charges. The prosecution appealed against the decision, against the discharge of all 3 charges. The High Court in this case actually allowed the appeal and convicted the employer and imposed 10,000 for each charge, so in total of 30,000. So as I said, this offense is a very serious one, so employers should be aware about this duty to ensure that their employees or foreign domestic servant have the valid permits. Now, what if you employ more than 5 employees at one point of time? So you employ more than 5 employees without permits, and if you're found guilty of this offense, you'll be liable to imprisonment of not less than 6 months, but not more than 5 years, and you will be liable to a whipping of not more than 6 strokes. So it's a very serious penalty. Now, I have also listed down a few offenses that does not, it doesn't only apply to employer, it applies to everyone. So these are the offenses that I think the employers should be aware of. So the first one would be the employer should be aware of, if you have, let's say if you have a premises or factory, you should not permit illegal immigrants to enter or remain at your premises. So if you as an employer, you own this premises, you own this factory, or you own this office, and if you're found liable that you're found liable to have illegal immigrants staying in your premises, and if you're found guilty, you'll be liable to a fine of not less than 5,000, but not more than 30,000 ringgit, or you'll be imprisonment of not exceeding 1 year, or both. Again, this is for each employee. It's not your first offense. If this is a second or subsequent conviction, you'll be liable to a fine of not less than 10,000 and not more than 60,000 ringgit, or imprisonment of not exceeding 2 years, or both. Again, this is for each employee. Okay, the second offense here is harboring illegal immigrants. So any person, including employers, should not harbor illegal immigrants. That itself is an offense. If you're found guilty of the offense, you'll be liable to a fine not less than 10,000 ringgit, but not more than 50,000 ringgit for each person that the person harbored. Again, if this is more than 5 persons, if you're found guilty, you should be liable to imprisonment of not less than 6 months, but not more than 5 years, and whipping of not more than 6 strokes. Now, the last offense, which I believe my colleague Anis has already mentioned, I'll just quickly run through this. Again, this is about falsifying, forgery or alteration of documents. So again, I think employers, you always hear situations where maybe the employers try to falsify documents for their employees or the domestic servants. This itself is an offense. If you're guilty, it will be fined of not less than 30,000 ringgit, not more than 100,000 ringgit. Imprisonment of not less than 5 years, but not more than 10 years. And whipping of not more than 6 strokes. I'll move on to the last point of today's talk, which is powers of immigration officers to conduct inquiries, interrogations, and to search and arrest. Actually, they have more powers than this. I'm just giving examples here. Before I go on to talk about the powers of immigration officers, I would just like to give you some knowledge about Immigration Department of Malaysia. So the functions of Immigration Department of Malaysia here, I have listed down here. There are 4 main functions. First one being issuing passports, travel documents to Malaysian citizens, and also permanent residents. The Immigration Department of Malaysia will also issue visas, passes, and permits to foreign nationals entering Malaysia. So what Anis has covered earlier, these are the functions of Immigration Department of Malaysia. And they also manage the movement of people at authorized entries and exit points. I believe Anis has also covered this. And lastly, it's about enforcing the immigration laws. I have summarized the powers of immigration officers to 5 different powers. Here you can see they have the power to arrest and detain, they have the power to make inquiries, the power to interrogate, power to search and arrest, and power to send a person to the immigration depot. So the powers of immigration officers, it's quite a wide ranging of powers that they have. And let's talk about this in more detail. So first, the power to arrest and detain. Immigration officers can arrest a person liable to removal from Malaysia without a warrant. However, this arrest must be authorized by the Director General of Immigration or by a senior police officer. What does liable to removal means? So under the Act, doesn't specifically define what liable to removal means, but basically it means that a person who is, after being examined by the immigration officer, is regarded as an illegal immigrant or prohibited immigrant to enter Malaysia. So he is liable to be removed from Malaysia. Now, the immigration officers can also detain that person in prison, police station, or immigration depot for a period of not exceeding 30 days, pending the decision as to whether his removal should be made. Of course, this power doesn't only apply to immigration officers. Here you can see the third point. The police officers can also arrest, detain, or remove any persons in violation of the Act. The second power is the power to make any inquiries. So immigration officers, they have the power to make any inquiries or to require any persons to produce any sort of documents which they deem necessary. These are related, the documents should be related to passes, permits, certificates, or any other sort of evidence to support that this person should be allowed in Malaysia. Also, they can require that the person to present himself for the purposes of inquiry. So he may ask the person to go to the immigration office for the purposes of inquiry. He may also require the person to submit to an examination by the medical officer. And if that person fails or refuses to comply, this in itself is an offense under the Immigration Act. The third one is the power to interrogate. So immigration officers can question any person being liable to move over from Malaysia regarding questions and inquiries, basically to establish his identity, his nationality, his occupation, and the details and the modes and means of travel. And under the Act, it actually says that the person shall fully and truthfully answer all the questions put to him and disclose and produce all the documents required by an immigration officer. So if you do not comply, it's a violation of the Act. The fourth one is the power to search and arrest. So immigration officers can enter and search premises, vehicles, or even persons actually, whether in public place or not, without a warrant, if he has reasonable grounds to believe that there is any evidence of commission of an offense on such premises or persons. If he has reasonable grounds to believe that there is such commission of offense, then the immigration officer can arrest without a warrant. Last one is the power to send the person to immigration depot for further examination. Let's say if the immigration officer wants to find out more about the person's validity of being in Malaysia, he can, as I say here, if he's in doubt of any person's right to enter in Malaysia, he can direct the person to an immigration depot, and he shall remain there until he is permitted to leave by the officer. And again, if he fails to comply with the directions by the immigration officer, he will be guilty of an offense under the Act. Now, I have reached the end of my talk point today. I'll pass the floor back to Vivien.
Thank you, Chee. We'll now take questions that some of you have posted on Slido. What are the sponsor's duty and or role? Anis, can you take this question, please?
Okay, thanks, Vivien. So basically, when I'm referring to a sponsor, it means someone who can ensure the maintenance and the repatriation of the person. For example, if he reaches an immigration offense, then the officers will check the sponsor and ask for the details of this person, his whereabouts. But basically what a sponsor would do is to say that he has known the person personally. He believes that this person is not a prohibited person, and he certifies that the photographs, which is a requirement when you're applying, that the person photographed is the person applying. So these are what is expected of a sponsor and his function and role. Basically, in the event that the foreign national is suspected or found to have breached the immigration laws of Malaysia, this person will be able to assist the authorities in helping to transport back the person to its original country.
Thank you, Anis. You're talking about the sponsor statement that is submitted for the visa application, right?
Yeah.
Thank you. Let's go on to the next one. If the employer does not furnish such information to the Director General, how would they know? Chee?
Hi, sorry, I was on mute just now. So if they do not furnish any information to the Director General of Labour, if the information is not furnished, then the application for visa will not be granted. And also if the foreign employee happens to commit an offense during his stay in Malaysia, and if he's caught, the employer will also be liable to an offense under Section 55 of the Act.
Okay, the next one we have here. For the duty to ensure that foreign domestic employees have valid permits other than the employer, will the employee also be liable for not having valid permits at the same time? Chee, can you take this?
Yes, the employee will also be found to have committed an offense, and the punishment of this is by a fine of not more than 10,000 ringgit or imprisonment of not exceeding 5 years or both, and also will be liable to a whipping of not more than 6 strokes. So I think it is the employer's duty to get the valid permits for the employee. but then if he is caught, then the employee will also be liable to an offense.
So I think to add on to that, so the duty is on yourself as well to make sure that you have a valid permit. Otherwise, because it's two different offences, the employer will fall under Section 55, if I'm not mistaken, whereas the employee will be would have committed an offence for illegal entry, which is under Section 6 of the Act. So they both bear same responsibilities to make sure that your stay in Malaysia is valid and legal. We'll move on to the next one. Oh, sorry. I think the question was, what are the rights of a person detained? Anis, can you take this?
Yep. So basically, the rights of a person detained is the same as any other citizen when you're arrested by the police or immigration officers. You have a right to be informed of the grounds of your detention. You have a right to communicate with persons, for example, your relatives or your sponsor in the country. And you also have a right to legal representation and a right to defer answering questions until you get that representation. And the difference between a detainee and someone, for example, who's arrested under different offences is that under immigration offences, you're actually detained for a longer period, whereas normally people would have to be produced before court, before a magistrate within 24 hours. For immigration detainee, the immigration officers have a longer period of time to investigate, which is actually 14 days.
Thank you, Anis. Let's go on to the next one. What's the difference with harboring illegal immigrants as opposed to permitting illegal immigrants to enter or remain at the premises? Chee?
Difference between harboring as opposed to permitting. I see. I suppose the difference is that for harboring illegal immigrants is that you are protecting them from authorities, sheltering them, giving them. So basically, to avoid the laws of the authorities, as opposed to permitting the illegal immigrants to enter, is where the employer allowing the employee to stay in their premises, to remain in the premises. Basically, I can understand that there is some similarities there, but then the difference is, as I said, the harboring part will be to avoid authorities so that he will not be found guilty of an offense.
Okay. What happens if husband is foreigner and employed in Malaysia and wife who is a citizen of Malaysia is not working? How is sponsorship provided if requirement is spouse sponsorship? Anis, can you take this, please?
The question is not that clear, but I would think that if you're applying for the pass or whatever of your spouse, it would be dependent on your employment. So whatever sponsor you receive, the husband received under his employment permit, the wife would rely on it in a way. But other than that, if you're applying for a spouse pass, which is coming from the employment of your husband, for example, there's no requirement that you require a sponsor. It's other certain conditions that you have to fulfill.
Yeah, I think here the question is the wife is a Malaysian of citizen. So if the wife is a citizen, I don't see why you need a spouse visa unless you're going for another type of pass which you have in mind. Because if, like you said, if the husband is foreigner and employed in Malaysia, then I believe he should already have an employment pass which suffices, I believe, right, Anis?
Yeah, correct.
Okay, let's move on to the next one. How to apply the transit pass? Anis, can you take this?
This one is actually, I need more details because the process actually varies from country to country, depending on which country you're coming from and which country you want to go to. But generally, it's either by referring to the embassy itself, or there's online. You can do it online before your travel. But transit pass, if you're wondering for the situation, for example, if it's just a matter of you traveling from one place to another place and you have a connecting flight, a transit pass is not required. It's only certain circumstances where a transit pass is required. If you don't leave the airport premises, for example, you don't need a transit pass.
Thank you, Anis. Is there a set monthly income required as proof of sponsorship for a spouse if applying for permanent residence, for example, 5,000 a month? Anis, can you take this, please?
Yeah, this one, there's no requirement because the requirement to show monthly income is not a requirement. You have to prove for example, if you're applying under the 2 million one, you have to, at the time you apply, you already have that money. There's no further requirements of the monthly income. But basically, from time to time, you just have to prove that you can contribute to Malaysia. The reason why you're allowed to stay is that you're contributing to Malaysia in one way. So long as you have that, then that's your proof. I don't understand what it means by proof of sponsorship of the spouse in this context.
For the person who posted this question, maybe you can rephrase your question, or you can contact us after the talk. Thanks, Anis. What's the difference with, okay, we've answered this. Are all detention offences compoundable, breach of duty to ensure foreign employees have valid permits, etc.? Chee, can you take this?
Hold on, just give me a minute. So breach of duty to ensure foreign employees have valid permits. Sorry, just give me just a minute, sorry.
No problem.
There are some offenses, like I mentioned earlier, that it's not just that it's only to compoundable in the sense that you can only just pay the fine. There are the offenses that I mentioned earlier. They are you are also liable to, let's say, imprisonment or maybe whipping. They only, I think, under the Immigration Act, there are only a few offenses that are compoundable. Section 6 of the Immigration Act, or Section 15 of the Immigration Act, basically it's not the ones that I mentioned that are compoundable.
Thank you, Chee. Next one we have, is there an offence if the foreigner is late in applying special pass during COVID as the appointment is not approved by the officer? Okay, I'm not sure what you mean by appointment is not approved by the officer, because I believe you will have to make an appointment online through the STO system. So what happened is that in the meantime, while your until the time of the appointment, you're supposed to be issued with a special pass pending the issuance of a new visa or the extension of your visa. So as far as I'm concerned, the Immigration Department has been quite compassionate when it comes to during the MCO period where visas cannot be renewed, but of course, genuine reasons need to be given. If you're unsure why your appointment is not approved, I think it's best if you contact them online, because the immigration offices are closed. So you can call us for assistance if you need further assistance in this matter. Okay, I think this question is combined, so I'll read it together. If a foreign wife was sponsored by husband to stay in Malaysia, but subsequently the couple divorced each other and the husband refused to sponsor the wife, looks like the foreign wife has to leave Malaysia. But if the wife has to take care of children of marriage, what is the transit pass procedure in Malaysia? Anis, can you take this, please?
I don't think it's related to the transit. Is it related to the transit question? But I think if it's the A1 and A2, yes, it would be revoked because your past would have been based on your marriage, but it can still be assessed in the sense that your children, if they've acquired citizenship, you can still have maintain your permit because your children remain a citizen of Malaysia. So it's either citizen or children of Malaysia. Sorry, the spouse or the children that's a citizen of Malaysia.
What is the transit pass procedure in Malaysia, Anis?
I think it's the same as the previous one, which it depends on which country that you're coming from.
Yeah, most of the time you can apply it online nowadays, right?
Yeah.
Okay, thank you, Anis. If at all the offences such as falsifying document is done by an agency that deals with documentation, who would be liable for the punishment? Chee, can you take this, please?
Yep. Of course, it depends on, according to the Act, it says that the employer will be liable. So if the document specifies the name of the company, the directors of the company will be liable, unless the company or the employer can show there is such a connection to some other companies. But I would say, in the end, it's still the company who is liable, because the company is the one employing the employee. So yes, the company will be liable.
Can you clarify on the 3,000 penalty mentioned under the common offences as discussed just now? Chee?
Sorry, 3,000 penalty for which?
Under the common.
Yeah, I
think it was
I
under.
would need to. Sorry.
So I think it was under my part. Basically, I mentioned that.
Sorry.
Nice.
Although the offences stipulate the penalty, the fine and imprisonment and six strokes of the rotan, there's such a thing as compoundable offences. In law, basically, it just means that you, instead of proceeding with prosecution and going to court and all that, you admit that you committed the offence, basically, and then you have to pay for the you opt for the lesser penalty, which is just a fine, which will save you time from going to court, and it will end the matter. You don't have to go to court anymore. You just pay the fine, and basically that's how a compoundable offence works. And under the regulations, it mentions that the compound available is 3,000, meaning it can be anything so long as it doesn't go over 3,000, but this is not automatic. It's still up to the discretion of the officers. So for example, he will consider whether this is your first time offense, whether you've committed a grave offense. For example, although you've just illegally entered, but you're here to do prostitution, aggravating factors or mitigating factors, they will consider. And it's not to say that if you're found liable under any of these offences, you can ask for and demand for just to pay 3,000. No, it's still up to the discretion of the prosecuting officer and the immigration officer how they want to penalise you.
The next one we have, is there a requirement, minimum income, etc. for a foreign employee to act as a sponsor to bring his spouse to stay here throughout his employment in Malaysia? I think we've discussed this just now with Anis. That there's a difference between an employment pass and a dependent pass. So if we're talking about employment, if he already has a job here, if he's been hired here as a foreigner or an expat, he should already have an employment pass, and that should suffice for him to stay here. He doesn't need a sponsor with financial stability and etc. Whereas if you're talking about a dependent pass under the MM2H, as let's just say, then you will need a minimum income of 10,000 ringgit a month, and you have to show your documents and etc. So I think this is something you need to distinguish, I feel. So if we are not clear, maybe you can contact us after this call, after this talk. Okay. Why is the transit procedure different for each and every country? Shouldn't there be one common procedure since transit is in Malaysia? Anis, can you explain this?
Basically, it's just the same. It's the same as why some countries require visa, some countries don't. It's just a special relation between the countries. For example, the Commonwealth countries may not require the transit visa because we have the special agreement that those citizens of those countries coming into Malaysia, they have a special status in Malaysia. So that's why it depends on which country. So it will be different if you're coming from US and you're going to India, and for example, if you're from India coming to Malaysia, going to China. So that's what I mean by it depends on each country. It depends where you're coming from and where you're going to, and which citizen. Not that where you're coming from, but it also depends on which citizen you are. So if you're a Indian citizen coming from the US, it's different compared to American coming from the US entering Malaysia.
Yeah, it's based on the diplomatic relations between our country and a specific country. So with the transit pass, so there's a difference between transit pass and transit visa. So certain transit pass is easily obtainable and it allows you to transit Malaysia for maybe up to 90 hours, and some countries it's 120 hours. So that's what we meant by different country has different requirements. We'll take a few more questions because our time is running short. For resident pass, can the applicant move to a different company? Any liability for the first company that signed the no objection letter when applying? Anis?
It's possible to answer the first part of the question, whether you can move to a different company, yes, but you must get written consent from the controller. You must get written consent from the immigration officer. It's not to say that it's outright not allowed, but you must get written consent. Whether there's any liability for the first company that signed the no objection letter, there's no liability because there's no liability on them that you want to change. It's the liability falls on the person to apply to say that they're changing companies.
Thank you, Anis. If every transit procedure is different, can you give one example at least? I think we've answered this question just now. If you're unsure, please give us a call after the talk. Is there a possibility where a person falls under few categories for entry permit? Example, spouse point system, does it affect their passes, Anis?
You would choose the most suitable, and we can only advise you, but it will be up to the immigration department. They will guide you in this. There are specific guidelines, but it won't really affect your pass. You will just have to apply to change. For example, if you came on a spouse permit, you want to get employed. Under the spousal permit, you're not allowed to be under employment. But once you get the written consent and you want to start working, then you just change your pass to employment. That's how it would be. It wouldn't be affected, but it's just that you have to apply for the more relevant one and change.
Yeah, the more relevant and the one easier for you, the one where you meet most of the requirements. And when it comes to passes, I think the different passes have different, allows you to do different things. So it really depends what's the purpose of you applying for the permit. Okay, I will just take the final question here. I'm a foreigner with employment pass with my employer. What visa options are available to allow me to work for any company in Malaysia? My wife is Malaysian. Anis, can you take this, please?
I don't. The question is quite confusing because if you're already in employment, you already have an employment pass with the employment, there's no need for you to consider the visa option. The visa options would just determine your number of entries and if you want to leave during your employment in Malaysia.
Yeah, I think most of the employment pass is multiple entries, if I'm not mistaken. So yeah, okay. That's the end of our Q&A session for today. Thank you for your questions and thank you, Anis and Chee, for sharing your insights with us. Before we conclude, I have a few announcements to make. First of all, please join us again for our upcoming talks. On the 2nd of December, Priscilla Chong, our firm's associate, together with me, will give a talk on the things you need to know about the duties of executives and trustees, followed by a talk by our senior associates, Ms. Hannah Patrick and Ms. Denise Pang, on 16th December on sale and purchase agreements. So you can sign up for our talks either on our website or by scanning this QR code. Secondly, please fill in our feedback form and tell us your thoughts about our talk. The link to the form will be posted in the chat group. If you have any other questions that we did not manage to answer earlier, we apologize. Please fill in our feedback form and we will get back to you as soon as we can. We appreciate your comments so that we can continue to improve our online talk series for you in the future. We really hope that we have answered all your questions. If we haven't, please feel free to contact us. Thirdly, please follow and like our social media accounts. Thank you everyone for joining us.
Thank you.